Hi students, in this video we're going to take a look at the case Ashcroft versus the Free Speech Coalition. This is a case from 2002, and if you read the case already, you'll know that it involves a statute, the CPPA, which banned virtual child pornography. And what they're going to be looking at, right, is sort of the question, I guess, that they're looking at is whether or not that statute violates the First Amendment's protection on free speech. So we might all agree, right, that virtual, child pornography in general is bad. Virtual child pornography is bad as well. But is that kind of material protected by the First Amendment? That's going to be the question we're looking at in this case. All right, so to start, we want to look at a little bit of the background. And this case is interesting because it sort of avoids some of the problems caused by some other kinds of material. The first case we want to look at is Miller versus California from 1973. And in that case, the U.S. Supreme Court established that pornography can be prohibited only if it's obscene. And it gave sort of a three-part test to see what counts as obscene. The first criterion is that the average person who's applying the community standards would have to judge that it appeals to the prurient interest. Now, prurient interest isn't a word that we use very often. So the idea here is just that it's trying to be sexually arousing. That's the idea there. Number two, the material would have to depict or describe in a patently offensive way sexual conduct or excretory functions that are defined by the relevant state. And finally, it would have to lack serious literary, artistic, political, or scientific value. So, to summarize, the idea would be that in order to be obscene, the material would have to depict some sort of sexual conduct or excretory function that's sort of trying to be sexually arousing in a way that's like a bit outrageous, beyond the community standards, and that lacks any sort of artistic or scientific value. So maybe you're going to have manuals, right, depicting sex in a textbook or something, but you might say, well, those have like clear scientific educational value, and so those shouldn't be outlawed. Of course, those are probably also not going to count as patently offensive, right? So the kinds of materials that we're talking about here that are obscene are going to go beyond, right, the kinds of pornography that most people would have access to, right? Even given access to the internet, though that kind of speech is protected, so obscenity has got to go beyond that. Okay, so in New York versus Ferber, so this is about 9 years later, the Supreme Court established that child pornography can be prohibited even if it isn't obscene, in order to protect children from exploitation. Now the thought here is that there might be some material that doesn't fit those three criteria we just gave, but that depicts children involved in sexual activity, and that we want to rule out. We want to prohibit that. The reason why we would want to prohibit that is not because it's somehow outrageous or offends our sensibilities, but rather because it promotes the exploitation of children, right? So in order to get child pornography to sell, we need to use children, and the thought is children can't consent to that kind of the relevant kinds of activities, and so that sort of material, in creating it, you're necessarily violating the law. And so we're going to rule out, we're not going to protect child pornography because of the harms that it causes to children. But since that time, right, since 1982, technological developments have made it possible to create realistic images of children who don't exist at all. So it seems like we could create child pornography that doesn't exploit children. And if that's true, then child pornography might not be the kind of thing that we should be able to prohibit. So the thought is virtual child pornography, right, wouldn't cause the harming, wouldn't cause us to harm any children, And so it sort of doesn't fit the obscenity test, it doesn't cause any harm, and so we should allow that kind of pornography. In light of those developments, Congress passed what's called the Child Pornography Prevention Act of 1996. We'll call that the CPPA going forward. In his majority opinion, Justice Kennedy says, the CPPA extends the federal prohibition against child pornography to sexually explicit images that appear to depict minors but were produced without using any real children. So the idea there is just that the CPPA sees, right, that there's this sort of gap, and so it says, well, we want to fill in that gap. We want to prevent child pornography that's created virtually. In particular, section 2256(8)(b) of the CPPA prohibits any visual depiction, including any photograph, film, video, picture, or computer-generated image or picture that is or appears to be of a minor engaging in sexually explicit conduct. So there we've got sort of the text of the statute. And note that it doesn't have to actually be a minor engaging in sexually explicit conduct, or right, it just has to appear to be a minor engaging in sexually explicit conduct. So with all those facts, right, now we're led to the central legal question, and the question is this: does the CPPA violate the First Amendment by abridging the freedom of speech? So remember, the First Amendment says Congress shall pass no law abridging the freedom of speech, and it seems like we might think that something like Mill's harm principle is relevant here, so we can't stop someone from saying something unless it's causing harm. And we look at virtual child pornography, and the thought is, well, it doesn't harm anyone. So if I'm just looking at virtual child pornography in the privacy of my own home, is there should I be allowed to do that? Should that kind of thing be protected? So that's something I want you to think about, right? Consider, does the CPPA violate the First Amendment by abridging the freedom of speech? Why or why not? So consider that. And in asking why or why not, right, and thinking about, make an argument for your view. If you think, yeah, it does abridge the freedom of speech, this law should be stricken from the books. Why do you think that? If you think no, this doesn't abridge freedom of speech, or this kind of behavior shouldn't be protected, why do you think that? What sort of reasoning would you give? Again, these legal questions, right, might be questions that we sort of feel like we're a bit out of our depth, right? We don't know the law as well as the Supreme Court justice. We need to know, what would they say? But you might be able to have some sort of intuitions or some reasons for thinking that the justices should rule one way or the other here. All right. So before I look at what the majority said, I want to look at Ashcroft's arguments. So these are the arguments being made by Ashcroft. He was the John Ashcroft, the Attorney General of the United States. I think that's right. And so he sort of says, like, this law is a good one. And he's arguing against the Free Speech Coalition, which is sort of a group of I don't know, I should say like a conglomerate of like adult film and adult material companies, and they sort of have this group called the Free Speech Coalition that defends their kinds of positions that are good for their organizations. Okay, so Ashcroft's arguments, he makes a few of them. So first, he points out that pedophiles will use virtual child pornography to encourage children to participate in sexual activity. So the thought here is that pedophiles can say, like, hey, look, here's this picture of this child doing this thing. Why don't you do that thing too? So it would help them create other child pornography or otherwise engage in sexual activity. So it's a kind of look at this person's doing it, you should feel okay doing that too. The second kind of argument is that pedophiles are going to use the relevant images to whet their own sexual appetite. So the thought is they're going to look at virtual child pornography, they're going to think, oh, like that kind of thing looks exciting, I want to go find a real person and, you know, a real child and have them act this thing out with me or whatever the case may be. So, and then the third argument, without such a law, you might think it'll be difficult to prosecute the possession and distribution of actual child pornography. Why? Because anyone who's got child pornography can say, like, well, that's just virtual, that's not a real child, and then it's going to be tricky to figure out, you know, how did this person actually get this material? Was an actual child harmed in the creation of it, exploited in the creation of it, or not? And so if they can always say, well, it's just virtual, then it's going to be hard to punish anyone for looking at actual child pornography. But the court did not rule with Ashcroft. So it ruled 6-3 that the CPPA does violate the First Amendment. It was not persuaded by those arguments. And we're going to look at Justice Kennedy's majority opinion. So Justice Kennedy is another person like Sandra Day O'Connor. I think Justice Anthony Kennedy. He retired not too long ago. Was replaced by Brett Kavanaugh. And Kennedy was another sort of moderate, right? After Sandra Day O'Connor, he sort of ends up being the person. I mean, he served on the court with Sandra Day O'Connor. They were both sort of about the middle of the road, and they often ended up having an influence on which way the court ruled in any particular case. In this case, he gave a few reasons for holding the views that he did. First, he said that this law is too broad. It seems to outlaw like Renaissance paintings that would involve children engaged in sexual activity. It would seem to outlaw maybe pictures and psychology manuals, and it would outlaw Hollywood depictions of teenage sexual activity. Like he thought something like, you know, maybe Romeo and Juliet or something like that would be outlawed by this. By the CPPA. Along those lines, right, it would prohibit movies that address just how bad sexual abuse is or the theme of teenage sexual activity in general. The second worry is that it chills protected speech. So the thought here isn't that it's sort of prohibiting things that have artistic value or, you know, educational value or something like that, but rather people who are producing speech that counts as protected might be hesitant to release that material on account of the fact that it would appear to be children engaged in sexual activity. So maybe the thought is something like this. Imagine that you are producing pornography and you have young models, right? Maybe they even look younger than adults. They look like children or something, but they're actually not. The thought is maybe this law would prohibit you from producing and selling that material because now you're going to get charged with violating the CPPA because your material appears to depict children engaging in sexual activity. So, as I say here, right, the penalties are stiff, so stiff that it might discourage legitimate publishers and maybe producers from distributing images that we think should be legal and should be protected. Now, what both of these sort of sides, I guess the philosophical questions that get raised from this case are as follows. So first, we want to just figure out, are there some acts like creating, buying, and or selling child pornography that should be prohibited even if they don't cause any harm, right? So say, again, I use the example of the person, right? Say, who just is at home looking at child pornography. Are they doing something that should be prohibited, right? Say they don't harm any actual children. Should that behavior be outlawed or not? Even if, right, we're assuming, right, even if it doesn't harm anyone. And if so, right, why is that? Why should we outlaw it? There are a couple different reasons someone might give. So one, maybe because those sorts of acts are immoral. Maybe we just say, it's immoral to look at child pornography. So it's not a matter of harm, it's just a matter of morality. A second reason might be because even if it's not actually harmful, it has the potential to be harmful, or maybe it's likely to be harmful or something along those lines. So you might think, even if the person sitting at home looking at child pornography, etc., doesn't actually harm anyone, merely looking at the child pornography makes them more likely to harm someone. Now, I'm not saying that that's true, but the thought is just, if it were true, would that be enough to justify us in prohibiting it? So one question I want to just end with is this. So let's say, and I think the justices sort of talk about this in the opinion that you read, it's that there's no real good evidence to show that virtual child pornography really does, in fact, make people any more likely to commit sexual violence against children. And so in the absence of that, we might wonder, what should we do? So should something like virtual child pornography be prohibited until we can show that it doesn't cause harm? That's sort of like a risk-averse approach. Or should virtual child pornography, something like it, be permitted until we can prove that it is harmful? That's maybe like a more pro-liberty or freedom approach. We're going to let people do this thing until we can show that it is in fact harmful. So I think that's the big question at the end of the day. Yeah, like one thing that occurs to me as I'm just thinking about this is, in our society there's this debate over whether or not, in lieu of the coronavirus, whether or not people should be wearing masks. And, maybe early on there's this thought like, should people be required to wear masks until we can prove that we don't need to? Or should we take this other approach where we allow people not to wear masks until we can prove that wearing masks is beneficial? And so I think that's sort of like a tricky question when we're interested in how much liberty should we be giving people. Can certain things be like sort of guilty until proven innocent, or should we think of them as innocent until proven guilty? All right, that's it for this lecture. Hopefully I would encourage you, right, to reflect on this kind of question. We'll be sure to talk about this one in class. All right, have a good one.